Meeting will be called to order. Join me in the pledge of allegiance, please. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The clerk take roll call.
Supervisor Johnson,
Present.
Clerk Rocco, here. Treasurer Davis. Here. Trustee McKay.
Here.
Trustee Menke.
Here.
Trustee Blanchard.
Here.
Trustee Hoffman. Here. 7 present. We have a quorum.
Okay. We are here for a FOIA appeal. Adam Heikler FOIA appeal, and at this time, I'm gonna turn it over to our attorney representative, Attorney Seth. How does last name? Seth Coaches.
So, okay, so to start, I know Adam filed a FOIA appeal, and was he given the date? Oh, he's here?
Yeah, he's coming.
Okay, so just wait for a minute for him to come in then, because
Yeah,
it's a good deal.
let's wait.
Okay.
Okay, we go back on the record.
Okay, so to start, we're here for a FOIA appeal, all right, which Adam had the right to do. He submitted a FOIA request on October 15th, and I believe on October 16th, a 10-day extension was issued, which is in compliance with the FOIA statute. The reason why it was the 10-day extension was necessary, a lot of times the records aren't at the township to access, and I think in this case, it was a township IT carrier that had to pull the actual records. So something like this is very common, okay? The records are somewhere else. You have to do the extension in order to get them. So I did see that on October 20th, that the Joyce, she did contact the IT carrier and said, hey, I need a cost estimate on this FOIA request. The FOIA request was provided to them. So they were providing, they had the information. Several problems here. First, the IT carrier was not responsive, okay? And I know that there were several communications that were made to the IT carrier inquiring about this, and they didn't get back to us, and they didn't get back to us, I think, until November 7th, okay? Now, the issue with that is that's well past the deadline of when Adam wasn't entitled to his records. The issue here is that, and the timeline was long. That is what it is. The issue here is there was nothing to produce. Okay, when the day came for when his FOIA was due, when his records were due, we didn't have it. There was nothing to give him. Okay. On the other hand, if you issue a decision, grant something, deny something, grant in part, deny in part, you have nothing to base that on. Okay, and if you did a cost estimate under that circumstance, that is 100% arbitrary. Okay, and that's not fair to anybody. It's not fair to him. And I don't think that's fair to the township either, because if that cost is way off, you still have to pay the cost of processing that. So that's the first issue, okay? And that has nothing to do with the appeal of the actual cost estimate, which we'll get to in a second. That was the basis of how that FOIA request timeline was wrong, okay? And you know what? Your IT carrier is VC3, I think.
Mm-hmm.
I don't personally know them, but I'm under the impression that they do work with municipalities. Is that right?
Mm-hmm.
So if they work with municipalities, then they know what FOIA is. Okay, they know. And in this case, she gave them the FOIA request. Okay, they should know that there's deadlines associated with this. It's an important thing that you got to take care of, especially if they work with municipalities. So I can't, really speak to how or why they did what they did. Okay, but here we are. So secondly, we'll get to the cost estimates, and I see on Adam, he had several, he's doing several things, which he's entitled to do, and we'll get to all that. First, when we talk about cost estimates, okay, the FOIA statute allows cost estimates. And if the amount is more than $50, you can request that the requester pay 50% of that as a deposit. Okay. Now, when these cost estimates are compiled, there's a few things that go into it, and this is the thing with FOIA, right? On its face, it's very straightforward, right? Everyone in here is entitled to submit a FOIA request to a public body, and you're entitled to get those records. Okay, on its face, it's very simple. When it gets to actually processing it, getting the records, to doing cost estimates, to going through all that, that's where it gets a little complicated. Here's the issue that led to the cost estimate being high. First, the IT carrier came back with 3 hours of time. Okay, and I think that $202 an hour, so it's $606. Okay, for their cost estimate. I don't know how they came to that number. Okay, that's what they gave us. Okay, now here is the issue with this that we see. When we see cost estimates that are several hours, that is indicative that there are a lot of records. Okay, whether or not that's true or not in this case, I don't know. Okay, but that is indicative of a lot of records, and that's part of how a cost estimate, which is just an estimate, is compiled. We have an attorney in my office that primarily handles a lot of FOIA requests. And when he sees cost estimate or estimates from IT companies that are several hours, the history has been, yeah, there's a lot there. There's a lot to go through. It's not just emails, it's email threads, it's attachments, whether it's, videos, whether it's like an insurance policy. I mean, we've seen attachments that could be quite long. And that's that's a real challenge. To give you context, is for a FOIA request like yours that I'm submitted, if there wasn't a lot of records, right? Like one of the more common FOIA requests that we see is records, communications between the township board and the township attorney's office. That happens quite a bit, and that's fine. When our IT carrier processes that request, you enter the keywords, my email address or whoever's email address, the board's email address. And the act of actually getting the record really doesn't take that long to enter the keywords, right? What takes a while is you look at the download. Okay, if the download is short, then there's not much there, right? If the download is longer, that's indicative of no, there's a lot of things there, and that's what happened here, right? You see 3 hours of time, and that's that cost estimate from the attorney who prepared it is consistent with what we've seen. And that's how it was compiled. Now I understand that it was late. That is true, and the FOIA does provide for a reduction, and that was accounted for in into the cost estimate itself. So there's
Can I get a point of clarification for the record?
Sure.
Okay. The FOIA appeal is being presented entirely by counsel who drafted the underlying determination and fee estimate. I object to any characterization of this as an independent board review unless the board itself states on the record that it has reviewed the request, the timeline, the fees, and the exemption, and is making its own determination under Michigan FOIA. Thanks.
Okay.
I don't make decisions. Okay, I'm telling you what the law is and how the calculation was. I didn't do the cost estimate. Another attorney in my office did. So getting back to it here, that's how it was essentially compiled. Okay, I understand it's a lot. I understand that under the FOIA is half. Okay, and of the deposit, some of the issues that we've seen have been where the estimate, even if it's 2 hours, 3 hours, it comes in at a certain number, and the deposit is whatever it is. The way it works is that if the estimate was too high, the requester does get their money back. They're not paying more for something that costs. If the estimate was too low, they have to pay the difference. So now under the FOIA, there are provisions, and I gave them to you in that what I put together, and it does allow you to waive fees. It does allow you to reduce. Okay, that is provided by statute, so you absolutely have the authority to do that. Something that I don't know is how many records there are that were sent between specific board members. If you think there's a lot, then okay, that's fine. But that would be indicative of maybe, it's going to take some time to work through that. If you don't think there's a lot, then maybe a reduction, is warranted, right? That's what partly what this board needs to decide too. There's a caveat with that, and then I don't think it's the case with Bedford necessarily, but we've seen situations where a board has significantly reduced the cost estimate. And the actual cost was in the absolute thousands and thousands of dollars. And townships, they're going to be responsible for, processing paying those costs. But then also what happens is when it comes time to pay the other part of the deposit, the person is either, they might walk away saying, no, I can't afford that, or they appeal, the FOIA request, here, and it brings it to the appeal. So, it's not perfect, but that is gonna be in your authority to do, is to revise the cost estimate if you think it's necessary. So going through, what I try to do is give you a summary of kind of the procedural history and what happened there. And then secondly is, going through, what Adam, was appealing. So the contractor fees, I know he was asking for that being waived, $202 an hour. If you think that's reasonable, for a total of $606, if you think that's reasonable, you could uphold that. If you think it should be reduced or waived, you can do that too. You specify why, but that's certainly an option. Okay, the attorney fees, I talked about how, those were calculated. Similar thing, you could waive those, you could, reduce those, that's completely within your discretion of what to do. When, in his appeal, it said provide written authorization defining, the attorney's role of the FOIA. So under the statute, MCL 15.236, the township attorney is authorized to assist the FOIA coordinator. And that's actually relatively common. Where FOIA requests come through, there's liability associated with, there's potential redactions, things like that. So it's relatively common that the township attorney is involved. On the other hand, too, if we're not told about something, we also don't know it. So if you receive a FOIA request, it goes to the filed. That's not the case here, but that's generally speaking. Provide township FOIA procedures and guidelines. I believe those are on the township website. They need to be, and I think they are in this case. Provide a privilege log for any withheld material. So if there's records that are exempted out for attorney-client privilege or for whatever other reason, the record itself is still produced, but you redact out whatever the privilege is, or the whatever it is, it's redacted. You still provide the record. You also have to specify why. Okay, that's being redacted. Privilege log could be interpreted a couple different ways. In court, there's a very formal privilege log that gets compiled. Something like this, you have to specify why. So there's an explanation, a citation to a specific statute saying why something was exempted out. I did see some questions in the appeal about, the redactions, and personal, like confidentiality issues, invasion of privacy. That is an exemption. I understand public officials do have a lower expectation of privacy, but there are certain situations where there could be information transmitted over email that still would require a redaction for, an unnecessary invasion of property. The situations I've seen, the driver's license numbers, I've seen social security numbers, that's not good. Another common one I see is, if it's health benefits related, if there's paperwork they're submitting, or if they're trying to put their kids on a coverage, so you see children's names and like date of birth, like things like that. Like those would be, subject to like personal, confidentiality. It doesn't take any more additional time to review because when you review, you're reviewing for everything. Is there attorney-client privilege, or is there some other exemption that applies? It doesn't necessarily, take any long. So the document that I provided you shows you, the nature of his appeal. It provides motions, for your reference, because ultimately you're going to either uphold it, or you're going to, you could reverse something, you could amend, the cost estimates, things like that. That's completely within your discretion. So I'm happy to answer any questions if you have any. The requester is here. I do think he should have an opportunity to address the board as well.
Mhm.
Okay.
I have a question.
Sure.
So the 28, 35, 34, is that with your fees or is that we're gonna add the 606 for 3 hours?
That was 606 plus what, the estimated attorney's fees from the office was.
Okay,
Okay,
and so those get added on to a FOIA request?
yeah. So with, yeah,
So, and then again, can you go over the 74.88 an hour
yeah.
to equal
So
34,
under the
44,
FOIA,
48?
the most you can charge is 10 times the rate of, the hourly rate in Michigan.
Okay,
And that number you see reflects that,
okay.
the $74.
Just to be clear, that applies to the lawyer, not to the tech firm, so they can charge whatever they charge.
So, I'm sorry.
So the $202 an hour, I guess is, I'm trying to figure out why it's that much.
That's the IT part.
Yeah.
I can't speak for them, but that's the information that came back from IT.
So in all actuality, the VC3 could go up. Is that correct?
It could, they
It could,
have it for
yeah.
3 hours, which sounds like a lot, but that's what they said. It
It could go up.
it could go
or
up,
down.
it could go down.
Yeah.
Okay. So and then the attorneys have to go through all of that paperwork? Is that what?
Yeah, that's part of it, and that's,
Okay.
and that is, depending on how many records there are,
Okay.
depending on what the drive look like, depending on what attachments are.
Right.
And again, I don't know how many emails are in this case, but like the times I've seen where there's a lot of threats, where there's a lot of attachments that have luminous documents, especially videos. Yeah, I mean, that takes, I mean, I've seen it take a couple months sometimes. I mean, it's, and that's nothing that anyone really looks forward to doing, just so you know, going through all that. It's a long, deep process.
According to me, page 4, it says attorney fee. Just explain that whole paragraph.
Page 4 of, the cost estimate.
I think we're point of clarification, please. Where you're going. Just for the record, I do object. The board has not stated that it independently reviewed the FOIA request, the statutory timeline, the fee calculation, or the claim exemptions. I object to this appeal being decided based solely on counsel's presentation, particularly where counsel altered the determination under appeal. I am preserving for judicial review that this appeal is being handled without an independent determination by a public body as required under Michigan law.
For the record, it's on the record. So now I'm asking you to explain that attorney fee for me, that
Where
paragraph
are you, saying?
on page 4,
How it's calculated?
down at the bottom.
Point of order, I do need a yes or no response. For the record, have the board members each reviewed the FOIA request and appeal, and are you making an independent determination tonight?
We're gonna make an independent determination when we come to these individual, uphold or not uphold these. We're reverses, we're going to do that by the board. He don't have anything to do with it. So,
For the record, the board declined to
Point of
say
order.
whether it independently
Hold it,
reviewed
man.
the appeal. I object on it because of all statutory violations and procedural defects for judicial review. Thank you.
your statement on the record. On page 4. At the bottom where it says contractor fees. And then then it says attorney fees. He doesn't have this.
No, I think I found it now. Okay,
Okay,
so, okay, to go through this then, what you could see in the left-hand corner there, 1248. That was, the state minimum hourly wage, okay? So that, I see in parentheses there, it says 965, that's on the form, that's a little outdated, but the state minimum wage is what it is. So you could charge, 10 times that, which if you look on, charge per increment, it's $74.88, which means the hourly charge is $74.88. So what they did was they looked, Michael, who compiled this, is 2,800, minutes divided by 60. He came down to 46. Uh, that was his calculation. And that was based on the extent of when he saw 3 hours of time in his experience with processing.
no. Let me read to you.
It's the wrong, it's this page.
Says estimates at the top.
Oh, I'm on the wrong.
Yep, it's the, yep,
What wrong?
it's the appellate initial FOIA request form.
Okay. So what was the question again? I'm sorry.
I wanted you to read that to me. What the last line there says, well, the actual cost is $14,000. I
Yeah.
want to see what that paragraph means and where these numbers come to that.
Yeah, no, this is a different situation. I was giving it to you for context, right? Like, and this is extreme, but it's happened very recently where there was a higher cost estimate. A township board reduced it to, $200. It was $14,000 worth of work because of the nature of the request. And, the township had to process that request, and at that point, it's up to the requester to figure out what they want to do as far as, paying the balance of the estimate. Right, that's to show you what could happen. That's extreme. I don't think that's gonna, what happened here, but that's the caveat that needs to be explained.
Oh, okay, so now if we go back to page 3 and where it says request of relief, the first proposal down here, motion put reverse, and each one of these have to be dealt with individually, right?
Right, so what is said here in the first relief, acknowledge that the response was late and therefore denied by operation of law. That is 100% correct. Okay? If it's not responsive, then it's considered denied. All right? So what I'm saying is you want to reverse this now because we're granting it. Okay? Now, in a lot of ways, it's already been granted. On November 12th, a letter was sent to the requester saying it's granted in part, denied in part. Okay, so that already was done. Then that's when the cost estimate followed that. Moving through here, the failure was willful or intentional. That's going to be an interpretation of the township board. To summarize, the FOIA request, the 10-day extension was handled the next day. There were several attempts to reach out to IT who was not replying. You can interpret that how it is, but there were efforts made.
So did you just say some of it was granted, the FOIA, some of it was granted and some of it was not?
So that's typical. You're going to grant in part and denied in part because it's going to be denied to his request is going to be granted eventually, because of what he's asked for is public records. Okay. There's parts of it that may be denied if there's an exemption that applies that would be redacted out. Okay. So that's what that means.
So this first one is just a formality to admit or acknowledge.
I mean, it'd be a motion, it's to reverse the denial by operation of law. And then as stated in the November 12th, 2025 letter, and grant the request in part with redactions, to be made there under, and then those are the sections of the FOIA for, privacy and, attorney-client privilege. So it's acknowledging that, yes, by operation of law, it was denied. And we're confirming that it was granted in part, denied in part, as the letter, was mailed to the requester on, November 12th.
And we have proof to show that we did the effort, correct? The effort to get this, and it was late on VC's part. We have
Yeah, I
proof
think
to
that's
show
what,
that.
I mean, if I have the email, I think that's
Okay.
what it.
Yeah.
Yep.
Just making sure we're covered, yeah.
Yeah.
Okay, so we need a motion in here on this to acknowledge this.
I'll make a motion to acknowledge.
Okay, motion by trustee Report. Okay. We need a roll call vote now.
Treasurer Davis,
Question. On the roll call that I'm acknowledging, this is what I'm. Yes.
trustee McKay,
Yes.
trustee Meinke,
Yes.
trustee Blanchard,
Yes.
trustee Hoskins,
Yes.
supervisor Johnson.
Yes.
Clerk Baraco, yes. 7 yes, motion carried.
You want me to walk you through the next, there's several motions in that,
Yeah, but, what I do wanna, ask you, it doesn't explain that. It's 606 that we're getting ready to vote on.
Yep.
That is directed toward a cost to him?
so the $606 was compiled by VC3, your IT carrier. They charged $202 an hour, and they estimated 3 hours, which is how they compiled $606. So the way I broke this out for the cost estimate was review the contractor fees first. Do you think that's, reasonable or not? You could uphold it if you think it is. If you think it's not, you could waive it, or you could, reduce it in a way you see fit. Okay. Right above that in the contractor's fees, you can see, a couple notes, that I had. The second note does cite the statute that, says you could essentially get waived the FOIA fees or reduce. There's statutory authority for that. So I want to use, there's an enabling mechanism that lets you do it if you feel that's warranted. And if you do, say, and if there's a reason, say why in the motion.
This is an estimated cost, correct? Well, the actual cost, if he wants the information, you would have to pay. If we decide that way.
Correct, it's an estimate. So what's happened, whatever, it's $153 would be half of 602 or 606. So that would be half.
303.
303.
I'm sorry.
Yeah.
So $33. So if the estimate came back, if the actual cost from the IT carrier came back at 200, he'd be entitled to that.
Refund.
Yeah, to the refund. On the other hand, if it came back, higher for whatever reason, you gotta pay the balance. Yeah.
So I have a question. Do this. We're making decisions right now. When do we hear from the person
So
filing
we
the
could
appeal?
talk through it. I mean,
Before
I think the first motion that you voted on was, I think that was probably the most straightforward, motion that you're gonna deal with. You could do it a couple ways. You could let him present if you want. If you want, we could run through how, what these are and then have him present. It's completely with your discretion, but I do feel he needs to.
Yeah. Yeah, before we
Yeah,
totally do these, yeah.
So maybe then if you wanted to, kind of go through contractor's fee, attorney's fee, things like that, just so you could kind of follow along.
Beth, do you have a dollar amount for, because it's late, so there's a discount. Do you have that dollar amount?
Yeah, it should be the cost estimate. It's 5% per day.
And where would that fall under?
So it was added up the entire cost estimate and the number was reduced from there.
Okay, so it's already been taken up here.
In conjunction with the attorney's fee, yes.
Okay.
Okay.
Okay, what we got on here, we got it says proposed motion to uphold and then a proposed motion to reverse. So we wouldn't take two votes. That'd be either you for it or you're not.
Right, exactly. So I just gave you suggestions, like if you want to uphold it, that would be a suggested motion to uphold it. If you want to reverse it to either waive or reduce, then that could be a motion that you would suggest. So I don't tell you I'm not gonna tell you what to do,
No,
because it's a policy decision, but I wanted to give you at least what a proposed motion could look like.
The way this is presented on here. Well, I'll tell you exactly where I'm coming from. So it's on here two different ways that I don't really get. I want to make a motion to reverse. So now how does that work then?
So if you're looking at to reverse, it would be, if you look at the second motion, it would say proposed motion, it says reverse. Motion by a board member, seconded by a board member, and then to either, reduce or waive, whatever you decide. The cost estimate of $202 of hours for 3 hours of work, because.
I got all that, but
Yeah.
what I'm saying now, there's a motion up here that says uphold. Who's gonna make the motion against it? Or, I mean, that's either
You're choosing which
You're
one.
to choose.
the board's
The
choosing.
board's
Of
choosing.
course, are we gonna hear from him first or? And,
I
or
would
not?
recommend.
Yeah.
here.
Right,
Yeah.
Mhm.
I like to.
mhm.
On you, Adam, but there's no timer on this.
I just want to say for the record, I object to the characterization of the board's motion as reversing a denial by operation of law. Under MCL 15.235, section 3, the denial occurred automatically when the statutory deadline was missed. The denial as a matter of law cannot be retroactively reversed by motion. I acknowledge the board's decision to proceed with partial disclosure. But I'm reversing, I'm preserving for judicial review. So the untimely response, the unlawful fee calculation, assertion of exemption logs without a privilege log. I further request that the minutes reflect that the board relied on counsel's presentation and that I raised objections regarding independent board review and preserving all statutory violations and procedural defects. That's all I have to say.
Back to this right here. If I make a motion for it to be reversed or reduced, yada, yada. Then we'll vote on that and it's either carries or fails. And then we got a motion to uphold, carry or fail.
Okay, so I couldn't quite hear all of that.
Can you hear
No, push button. Yeah, there you go.
me? Okay. There's a motion here to uphold, motion by, somebody make a motion, then it's seconded, VCR's cost estimate, yada, yada. Then there is a motion to reverse. I said, I'm in favor right now. My thought process is to reverse or reduce these costs.
Okay.
So we'll vote on that. If it carries, so be it. And if it fails, then we have to make the motion again to uphold these costs.
There would just be additional discussion and then see, yeah, if there was a motion, how it would be voted upon. So if you're making a motion to reverse, I prepared a motion that you could use, and then if there was support for it, then discuss and come to a number. Are you waiving it entirely? Are you reducing it to a certain extent? That's a board decision there.
And if BC3 came back at the end higher than 606, we're liable for that. Not.
Well, you're gonna be,
Mhm.
you're gonna pay the processing no matter what. And if it came back higher, the estimate's just the estimate.
Mhm.
You know, when the total cost came back, they would have to pay the balance, which could be more or less.
Mhm.
Mhm.
All right, so I'm making a motion to reverse or reduce the VC's cost estimate of $202 an hour for a total of $606.
A second.
Well, how much are we reducing?
Well,
We have
we
to
can
know.
discuss that after.
Okay, that's good.
Okay, I made the motion. It was seconded by trustee Christie. Okay, discussion.
Thank you. What are your thoughts on reducing? How much?
I think everybody should look at it as everybody wants more transparency. So we probably should take that into consideration about being transparent, and the time that he has given has had to wait.
My thought process as we go around the table is that he didn't get the information in a timely manner.
Correct.
And now we're saying, but you got it, or you got some parts of it or whatever, but he's not getting what, he wanted a steak, but he got a pork chop. So I just can't uphold and say that $606, actually, he didn't get it in a timely fashion, period. And I'm big on, if somebody requests for I uphold that law. He didn't get it. So I don't know how we're gonna get me in good conscience charge that $606 regardless. And their estimate, it may not be that, but they didn't produce. That's my point.
So dollar wise, are you thinking,
I guess I'm not clear on it. So if they go, when they go ahead and do the work and they're gonna charge us $800, but we're saying we're reducing it to 200. Where's that other 600 gonna come from? Who's gonna pay that? That's my thought.
taxpayers?
Right. That would be the town.
Yeah, that's the scary part right there.
Do we think there are a lot of emails back and forth?
Well, who's looked into that? I mean,
Well, I
mean,
seem to know for sure, but I don't have any idea.
so you don't know from IT yet any?
I wouldn't, they won't,
They won't.
right, yeah.
I think their response was, they told you $202 an hour, 606. I think they said, let me know what you want to do.
Right.
I think that was an email. So they wouldn't even ballpark. So I don't know. I can't really get guidance on that.
Can we not charge him this for the estimate to get the work going and just have him pay whatever it costs us? But then along with that, I would be all for laying down on BC3 and letting them know that they bear a responsibility for this and not being timely to the response. So we expect some remedy from them on his behalf.
But in the same breath, I mean, what if it's more than 606? It's not fair to the person that has asked for the FOIA request. When, how late is it? It's over a month and a half late.
Right, and I agree with Scott on that too, and you both, but BC3 should hold some responsibility here.
Yeah, I would look at it as you asked for them, they didn't give them to you for
Right.
whatever reason, and you asked several times, okay? If you lose the FOIA, that's fine,
Mhm.
all right? That's a bad thing,
Mhm.
Right.
all right? There's no way around that. If you're gonna reduce it, I think, or I can't tell people how to vote. I certainly, would see that quite a bit, reductions, if not waived. And then I would see a township saying, IT carrier, you put us in a really bad position where there absolutely could be liability. And to hopefully limit or eliminate that, we're waiving the costs, okay? That's what I see.
I would agree with that. I imagine that they will come to some understanding with it.
Yeah, as long as
They're
we're
very
covered
aware.
on that, to
Yeah,
show we made due diligence to do it, then.
Yeah, and I can't guarantee anything between, the township and VC3. I mean, I can't, but that's what I see. When stuff is late,
Mhm.
Anybody else?
So what is the motion going to be to waive the fee from BC3?
Well, and we all have to come up with something. I say waive it. I know she requested it
Mhm.
and she dealt with them, but they didn't produce it.
Right.
So what does that have to do with him?
I agree with,
agree with that.
yeah,
So is it 0?
and then we follow up in BC3.
Correct.
Right, I said we get,
Yeah,
I agree.
yeah,
Is it 0 is what we're agreeing to?
I'll make a motion to zero it out.
I'll second it.
Don't get a vote
We
on it, right?
We already have the
You have to,
Johnson motioned it and we can second it.
so this is a reverse motion. So we had discussion, now I'm gonna take roll call.
so point of order, Mr.
Yes,
Supervisor.
sir. Yes, sir.
Do we have a motion on the floor that we've not voted? We were in discussion on.
Yes.
There's been a second motion. Do we have to vote down the first motion to get to the second motion?
Ordinarily, we would, but see, this is all comprised in the same answer, the same option. Normally, I would say close it, vote on this, and then vote again, but see, these are our options already here. Am I right? See, our options, if they weren't combined in there, yes, I would close the motion on the
And
floor.
so, just to be clear, it's because DC3 did not respond.
Yes.
And you're gonna be getting with them and talking to them? Or somebody else?
Yes.
Oh, yeah.
Definitely do a follow-up.
Yeah, yeah, yeah.
Roll call.
Yeah, so, from a motion to reverse to zero, roll call, please.
Trustee Blanchard,
Yes.
trustee Hoskins.
Yes.
Trustee Menke,
Yes.
clerk Baraco, yes. Treasurer Davis.
Yeah.
Trustee McKay,
Yes.
supervisor Johnson.
Yes.
7 yes, motion carried.
That's attorney fee.
I think the second,
Yeah, we're here.
proposed motion though, it says BC3. In the second.
Right here.
That's just suggested language, so.
Did we read it, the attorney fees?
Yeah, I'm going. Okay, now we're at, under attorney fees, where it says to uphold a motion, so such and such, to uphold the township attorney's cost estimated at $2,229.34, which calculation was contained on page 2 of the cost estimate provided to appellant, which these are the same numbers. And then we got a reverse to reduce DC3.
Yeah, that should just be the attorney's fee instead of BC3, that's the type of.
Okay. Reverse attorney fees, cost estimate, or waive.
I would motion to uphold the attorney's fees, less the percentage calculated by the time that we're overdue.
Was that already,
It was done.
that was already done if I,
Yeah, that was,
The 5% was taken off.
That's already taken, I'm sorry, I thought that was not taken off of this figure.
So the amount that you have, $2,229.34, that could
It
grow
could-
exorbitantly
I wouldn't-
possibly.
I'll tell you, between yesterday and today, I got on them pretty hard about this cost estimate, if you can put this together. And I said, you put this cost estimate together, I go, you need to explain this.
Yeah,
Okay, because I think it's important, it's an important thing. And, you know, they did, and, that's the numbers they came up with, that's what, I'm presenting to you. I don't like how DC3 put us in this position.
no,
I don't want the township to be in a position where there could be any liability through no fault of your own, okay? And I can't control what BC3 does either. If you wanna, I will take care of it on our end, okay? If you don't want to, I'll take care of it on it, so there's no additional cost. I don't want this. There's already enough problems, okay?
Then I retract my motion because I just didn't want the taxpayers getting hit with it.
so you're
So-
saying you'll lock it in at 2229.34.
No, I would, I'll waive it. I don't care. I'll waive it. I don't want you to be in a position that ends up in court through no fault of your own.
Then my motion's to reverse, the attorney's cost estimate of, $2,229.34, per the calculation in page 2 of the cost estimate, afforded, for the simple fact that we aren't being charged, so there's nothing to pass on.
There will be, I'll make sure that there's no cost associated with, from today on regarding, reviewing, those records once we got them, okay? It's whatever, okay, I'm not gonna worry about that. Either I'll do it or I'll make Michael do it and write it off, because this isn't fair it's not fair to really anybody in this room, but I'll take it right now.
Just to make sure.
Okay, on this reversal,
Yeah.
it was a,
Do you have a motion?
we have a motion.
Do we have a second?
Second.
Ms. Blanchard motion there.
I just have one more quick question, just to clarify, and I apologize. The 2229.34, you're saying we will owe you up today, nothing
No.
after today? No, that's, you have cleared out.
No, I mean, there were, the only real costs associated with it, I mean, yeah, like reviewing the appeal, finding out what actually happened, right? Writing up that memo. But after that, any costs associated with redacting for attorney-client privilege or for, the personal information, no. There's not gonna be charged. I mean, quite frankly, I'm not expecting that it's gonna be a huge amount of emails, but if it is a lot, then whatever, I'll deal with it on the weekend. That's my problem, I guess. But I'm not gonna put you guys in a position to face any sort of court action for something that none of us can control. At the end of the day, it's for it. He's entitled to records. He didn't get it.
Thank you.
Yeah, thank you, Tom.
Thanks.
okay, so now, where it says, reverse motion And then there was a typo there, so we scratched that out with VC. Then it says cost estimate of the 22-29 and change or waive VC3. That was another typo?
Yeah.
Okay. Just want to make sure. Okay, so I have a motion to reverse. It was a motion by trustee Blanchard,
Yes.
seconded by
That sounds okay.
trustee McKay. Roll call on the vote, please.
Trustee Hoskins,
Yes, with follow-up from VC3.
trustee Menke,
Yes.
clerk Baraco, yes. Treasurer Davis.
Yes.
Supervisor Johnson,
Yes.
trustee McKay,
Yes.
trustee Blanchard,
Yes.
7 yes, motion carried.
So one question that I think we should figure out is, I don't know when you're actually gonna get those records from IT. But if we could, it would be nice to have an expectation with the requester about when he should expect to get the records. Joyce, as soon as you get them, you send them to me and I'll make sure it's taken
Yeah,
care
I
of.
will contact them tomorrow.
But I just don't know what that timeline is.
Right,
You know, I don't, like, I know it's the holidays, I'm gonna be out of town for a week or so, I'm not trying to delay anything, but I don't wanna set an expectation and fall short. Is there a day that works for you? That we can get you those records?
Let me know whatever timeline is
Okay,
for you to make it happen. I mean, it's-
okay, we have no
whatever
interest in
your
drawing
time
this
is.
out. Okay,
Or make-
I have no interest in making this longer than it was already been,
No.
what happened shouldn't have happened.
Yeah, thank you.
All right, then that closes out this section. And,
So just move through the rest of that memo. There are, other aspects of this appeal that, I wrote answers to, but I don't necessarily think that there's action for action that was to be taken on that. So on number 7, it said, I believe his request is appeal said place this appeal on the next regular township board agenda and confirm any date and time. But the way this FOIA statute, is written is you have to have, an appeal hearing within 10 business days. So there was already enough problems with this. That's why we did the special meeting, and I believe, it was a daytime that worked for everybody. So we just moved it up to sort of get closure on this one. So there's a proposed motion on the back that, you know, the decision is essentially uphold the decision, to hold the appeal hearing today, because the parties agreed to it, just to tie that up.
oh, okay. So a motion to uphold the decision to uphold appeal hearing on December the 16th. We had already voted on that, but okay. That's why we're here. But anyway, as agreed by the appellant and the township, at which the appellant was present and had the opportunity to be heard. So, motion.
Support.
One second.
Second.
All right.
so it was motioned
said
by
something.
Johnson and then, seconded by McKay.
Okay, you take roll call.
Trustee Menke,
Yes.
clerk Baraco, yes. Treasurer Davis. Yeah. Trustee McKay,
Yes.
supervisor Johnson.
Yes.
Trustee Blanchard,
Yes.
trustee Hoskins,
Yes.
7 yes, motion carried.
May I ask one more question?
Yeah.
The, number 6, the privilege log,
Yes.
what exactly is that?
So there's a couple different privilege logs out there. One when you're actually like in a lawsuit, that's, you know, very formal.
Mhm.
But I think in this case, what I'll do in this case is if there is, items that are gonna be redacted for whatever reason, then, you know, state why it is, like an email dated, you know, whatever date. And this is the exemption, that's why it's redacted out. So he'll know why something was redacted. I don't know if there's gonna be redactions or not, but that's how that would work.
Yeah, okay, thank you.
They're all good on that. Okay. Moving on to item number 5, which is open now for public comment. Now you need to.
Yeah, the 3 minutes.
Yeah, this would be the.
This will be the 3 minutes.
This is
Thank
general
you.
public comment.
Yeah, thank you. For the record, I acknowledge and appreciate council's decision to waive the attorney fees. I accept that waiver as partial resolution only. I want to be clear for the record that my acceptance of the attorney fee waiver does not waive or concede the denial of the denial by operation of law under MCL 15.2353 due to the untimely response. Any objections to unlawful fees under MCL 15.234, including contractor labor, or any objections to improper redactions or the absence of a privilege log when asserting MCL 15.243(1)G. While the board has taken action this evening regarding disclosure and fees, a denial by operation of law already occurred, and that statutory violation cannot be retroactively cured by motion. I am preserving that issue for judicial review. Going forward, I request that any redactions be narrowly applied and justified on a record-by-record basis, that a privilege log be provided for any records withheld or redacted under attorney-client privilege, and that any remaining fee calculations strictly comply with the Michigan FOIA. Finally, request that my objections, written appeal, and statements this evening be fully reflected in the minutes. Thank you.
Anybody else wishing to speak in public comment? Seeing none. Reflections from anybody at the board?
Merry Christmas and Happy New Year. Yeah. This is gonna be our last meeting before Christmas, yeah.
Not going in the street, guys.
Nobody else has
Thank
any?
you, Bob. Thank you. for
Oh, yeah.
coming.
Yeah, thank you.
We appreciate
I'm
it.
happy to do it.
No more. This meeting is adjourned.